plotting over a period of 2.5 years to kidnap, rape and murder TV presenter Holly Willoughby, 37-year-old father of two, Gavin Plumb from Harlow, Essex, might spend the rest of his life behind bars. Plumb's crimes were, to give them their legal definitions, soliciting murder, encouraging or assisting the commission of rape, and encouraging or assisting the commission of kidnap. Having been convicted of those offences on the 4th of July 2024, Plumb was, on the 12th of July of 2024, sentenced by Mr Justice Murray at Chelmsford Crown Court to a minimum of 15 years and 85 days in prison, a life sentence. Mr Justice Murray made it clear that Plumb should not count on being released automatically at the end of that minimum term, or even ever. Here is exactly what Gavin Plumb did.
Over a number of years, you pursued an unhealthy sexual obsession with Holly Willoughby that led you ultimately to plan over that period to kidnap, to rape, and to murder her. You researched her home address, her security arrangements, her daily routine, her route to work, her family. You assembled a restraint kit. You bought what you believed to be chloroform to incapacitate her and her husband. You intended to harm her husband and her children as part of your plan. You attempted to recruit several people to help you. You discussed with Mark and with David Nelson, and no doubt others, in hideous and revolting detail, the prolonged sexual violence that you intended to inflict on Ms. Willoughby once you abducted her and had her under your control. You solicited David Nelson to murder Ms. Willoughby or to assist you in murdering her. You encouraged Mark and David Nelson to participate in your plan to kidnap and rape Ms. Willoughby. The jury saw through the various lies that you told at the trial and convicted you of these offences.
As an obese person who couldn't drive, Plumb knew that he needed assistance with his twisted project for Miss Willoughby. Over an 18-month period that began in December 2021, Plumb sent an Irishman by the name of Mark, a fake name one presumes, over 900 WhatsApp messages relating to his sick plan. Having got talking to Mark on an online chat room called Abduct Lovers, Plumb was convinced that he had sourced in this individual a suitable accomplice for his planned criminal enterprise. Plumb didn't in any way hold back on the evil that he planned to inflict on Miss Willoughby.
Many of the messages about what you planned to do to Ms. Willoughby were so horrifying, shocking, and graphic in detail that they were not read out in open court. The jury, however, read every single message during the trial.
Plumb took delight in showing Mark pornographic images of women tied up and gagged. On this point, one imagines that Plumb took delight in looking at the thousands and thousands of pictures of Miss Willoughby that he downloaded to his phone. These include a number of digitally altered ones where Miss Willoughby appears to be engaging in acts of pornography, deepfake porn. Anyway, not to digress, Plumb also told his putative accomplice of his prior convictions involving violence against women, one in 2006 for 2 counts of attempted kidnap and one in 2008 for false imprisonment, the details of both of which I will soon reveal. He would later make these same disclosures to a second intended accomplice. Mr Justice Murray said that Plumb's reason for sharing these areas of his background were obvious.
During your exchanges, you boasted to Mark about your own convictions for your offences in 2006 and 2008. I'm sure that you did this in order to make clear to Mark that you were not a fantasist, but someone who had a proven record of sexually motivated violence against women, and that you intended to carry out the offences that you were discussing with him against Ms. Willoughby.
Plumb was indeed no fantasist. Even if we leave aside the matter of his previous convictions, we are likely horrified to learn of the important personal investments that Plumb had made into his plan.
It was during this period that you purchased online the rope, the metal cable ties, the utility folding knife, and the 2 bottles of chloroform. On the 6th of May 2023, you sent Mark the same video showing your restraint kit that you later sent to David Nelson. You carried out various web searches on chloroform that were primarily concerned with the legality of purchasing or owning it and its inability to incapacitate a person. The police subsequently discovered, upon analysis of the contents of the bottles, which were unopened when the police seized them, that they did not, in fact, contain any detectable level of chloroform, but only ethanol and water. You, however, clearly believed that you had purchased chloroform when you bought them online from a homeopathic pharmacy. Your claim in your evidence that you had bought the chloroform to clean a stubborn stain on your living room carpet was a particularly clumsy and obvious lie.
That almost sounded like a joke to me. I had actually read somewhere that Plumb had alleged that the chloroform, or what he thought was chloroform, was to clean a difficult stain by his fridge freezer. But to me, that is just as clumsy as the reason cited by Mr. Justice Murray for Plumb's possession of the apparent chloroform. Honestly, Plumb is a plumb idiot. He came up with this non-cunning plan to avoid criminal liability in the event of being caught.
We're then going to force her to make a video just saying that she come with us under her own free will, that she's with us under her own free will. No, she's fully consenting into everything we do to her. So that covers us.
The man seriously expected people to believe that the beautiful and relatively young Miss Willoughby had left her husband, her 3 children and her very comfortable home to run away with an obese security guard, yes, security guard, from Harlow. What would he have answered when people asked him how and when he and Holly met, why she ran away with him, why she did it behind the back of her very husband and children, and where she is now? Plumb had, as far as he was concerned, got his whole project carefully and strategically planned out, from where to keep his intended victim.
At various times during your WhatsApp exchange with Mark, you discussed looking for an abandoned property outside of London where you could hold Ms. Willoughby. On one occasion in June 2022, you forwarded to Mark a photograph that had been sent to you of a room on an abandoned stud farm that you thought might be suitable for this purpose.
To what sort of pressure to use against her in order to derive her compliance with his evil schemes?
One particularly deeply unpleasant aspect of your exchanges with Mark, which did not appear in your exchanges with David Nelson, was your discussion of restraining Ms. Willoughby's children and using her fear for their safety as leverage with which to control her.
Much of Plumb's messaging with Mark serve as the basis for Plumb's respective convictions for encouraging or assisting the commission of kidnap and rape.
Your exchanges with Mark, together with your exchanges with David Nelson and related evidence, form the factual basis for your offences of encouraging or assisting the commission of the offences of kidnap and rape, with the intention that these offences be committed.
In autumn 2023, after being dumped by Mark, who backed out of the plan, which he did by blocking Plumb, Plumb began messaging, via the aforementioned chat room, an American by the name of David Nelson, whose real name we will never know, but whose status as an undercover police officer based in Minnesota, America, is what led him to contact the FBI about Plumb's plan.
Unfortunately for you, David Nelson was an undercover police officer based in Minnesota.
Plumb was arrested by Essex police in October 2023 on notice from the Metropolitan Police, whose intelligence on Plumb's plan, which had been relayed to them by the FBI, led them to deem that there was a real and imminent danger to Miss Willoughby's life coming from Plumb. Yes, Plumb totally and, thankfully, stupidly trusted that Nelson would serve him as an accomplice to his plan. As he had done with Mark, Plumb eagerly showed Nelson all the kit that he had amassed in order to fulfil his project, disclosed his criminal past, and hungrily affirmed that his schemes were serious, and so was he.
With David Nelson, you talked about the use of chloroform to incapacitate Ms. Willoughby and her husband, and you sent David Nelson photos of the bottles you had bought online. You sent David Nelson a video showing your restraint kit, which included handcuffs, ankle restraints, gags, an eye mask, ropes, and metal cable ties, as well as other BDSM equipment, including a whip. You had bought the ropes in February 2022, and you'd bought the 4 packages of metal cable ties in April 2022. You told David Nelson that you planned to use knives in the attack, including kitchen knives and a utility folding knife that you bought on the 1st of August 2023. David Nelson said that he lived in New York and he would only spend the money to travel to London if, quote, this was a serious thing, close quote. You said, quote, definitely serious for me anyway, close quote. You made a number of other statements to the same effect. I have no doubt that this was all considerably more than a fantasy to you. You told David Nelson that you'd been planning this for about 2.5 years.
Plumb's endgame, if you will, with Miss Willoughby was to slit her throat, cleanse her corpse with bleach and then load it into a lake. Murdering Miss Willoughby was Plumb's idea and it forms the basis of his conviction for soliciting murder, the most serious by far of his 3 offences, and the life sentence that it attracted reflects that.
It is clear early on during your exchanges with David Nelson that your plan was to kidnap, rape and otherwise sexually abuse Ms. Willoughby. When David Nelson asked you whether she was, quote, going to be returned, close quote, you said no. Later in the exchange, when David Nelson asked what would happen when you were, quote, done, close quote, you said, quote, slit her throat, clean her out, and dispose of her, close quote. Later still in the exchange, you made it clear that when you were finished, the plan was to slit her throat, wash her in bleach, and dump her body in a lake. You introduced the idea of murdering Ms. Willoughby into your exchanges with David Nelson, and you clearly sought to persuade him to participate in this part of the plan, whether it was to be David Nelson who actually slit her throat, or you doing so with his participation, assistance, or encouragement. That is the basis of your conviction for soliciting murder.
Plumb had form for kidnap and false imprisonment.
You have previously been convicted of sexually motivated offences against women, as I've already mentioned, involving the threat of violence and or unlawful restraint. On the 14th of August 2006, when you were 19 years old, you approached a young woman on the Stansted Express and gave her a note saying that you had a gun and that she was to get off at the next stop with you, or you would shoot her, yourself, and everyone else. Other passengers noticed her distress, and you got off the train at Stansted Mount Fitchett. 2 days later, you approached another young woman on the Stansted Express and gave her a note saying that you were a police officer and that she was to get off with you at the next stop for a, quote, quick chat, close quote. She refused, and you got off at the next stop and sat on the platform where the police found you later that day and arrested you. When arrested, you were found to have on you an imitation firearm and 3 rope ligatures. On the 16th of March 2007, for these offences of attempted kidnapping, to which you had pleaded guilty, you were sentenced to a term of imprisonment of 12 months, suspended for 2 years with supervision and activity requirements. On the 11th of December 2008, when you were 21, while you were working at Woolworths in Harlow, you approached 2 16-year-old girls who were also working there with a box cutter or Stanley knife type instrument, and you threatened them, telling them to get to the back of the stockroom. After failing to untangle a piece of rope that you had intended to use, you took out some tape and began to bind the hands of one of the girls behind her back. The other girl escaped, and the alarm was raised. The police attended, and you were arrested. On the 15th of June 2009, for these offences of false imprisonment, to which you had pleaded guilty, you were sentenced to a term of imprisonment of 32 months.
When passing sentence, a judge has to follow the Sentencing Code, which comes from Parts 2 to 13 of the Sentencing Act 2020.
All 3 of your offences fall within Schedule 19 to the Sentencing Act 2020.
When setting a sentence, a judge has to determine which category, if any, of the sentencing guidelines, which all judges work to where such guidelines actually exist, that is, applies. Where there are no offence-specific sentencing guidelines, a judge will refer to the general guideline overarching principles. Judges in the Crown Court might also refer to Court of Appeal judgments to look at how sentences have been reached for similar cases. As such, the following posed no problem whatsoever for Mr. Justice Murray.
There is no offence-specific sentencing council guideline in relation to any of these offences.
Plumb has 3 convictions. I'm under the impression that if he had made 3 separate plans for 3 separate victims, which were scheduled for 3 separate occasions, for instance, his sentence would have been substantially longer.
Given that all 3 of your offences were part of a single plan to kidnap, rape and murder Holly Willoughby, the correct approach in this case is to pass concurrent sentences that reflect the totality of your offending.
After addressing the matter of sentencing guidelines, the judge adjusts the starting point of a sentence either up or down in accordance with any aggravating or mitigating factors. Plumb had aggravating factors coming out of his ears.
Turning to the aggravating factors in this case, and taking care to avoid double counting, I find that your offences are aggravated by the following factors. A. Your prior convictions for violent, sexually motivated offences against women by way of attempted kidnap and false imprisonment. B. The lengthy and detailed planning of your intended offences against Ms. Willoughby over the course of nearly 2 years. C. The purchase of items to be used in the commission of the offences, including your restraint kit, a knife, and chloroform. D. The research you conducted into the personal life of Ms. Willoughby. E. The fact that you sought to encourage more than one person to commit these offences with you. F. The fact that you intended to commit these offences in Ms. Willoughby's home and to involve her husband and children and to harm them. And G. That your plan to carry 1 or more knives to the scene to be used in the attack and to be used to murder Ms. Willoughby.
The mitigating factors to Plumb's offences were mainly accidental or coincidental.
There is no doubt that if you had genuinely found 1 or more accomplices who were seriously interested and had been willing to join you in carrying your plan through, then you would have put this plan into action. Your plan was unlikely to succeed, given number 1, your physical limitations, in particular your gross obesity and the accompanying physical health aspects of that. Secondly, your lack of a car and a driving license, although I note that you were taking driving lessons, and having no driving license would not have prevented you from driving Ms. Willoughby's car. And thirdly, the difficulty you would have had in practice of bringing Ms. Willoughby to your own flat undetected, and your lack of any alternative premises in which to keep her, although you had researched various possibilities. The essence of your offences was the soliciting of murder by another and the encouraging or assisting of another to kidnap and rape. It is fortunate that you did not succeed in finding 1 or more others who might have been considerably more physically able, and perhaps more able in other ways, than you were at the time of the offending. You were born on the 25th of February 1987. You are now 37 years old. I have borne in mind your background of physical ill health, including increasing struggles with obesity to the point of gross obesity from the age of 13, as well as the social difficulties, physical health issues and mental health issues that have accompanied that. I have borne in mind that all of your research regarding Ms. Willoughby was done online and that you never went to her house or stalked her in person, although it is clear that you considered and discussed doing so.
In further relation to sentencing, Section 30 of the Sentencing Act 2020 states that a court must obtain a pre-sentence report before passing a custodial or community sentence unless it considers it unnecessary to do so. Mr. Justice Murray, as you're about to see, 100% only orders a pre-sentence report when it isn't blatantly obvious to him what a danger an offender is.
Given all that I know about you, having presided over your trial, I do not consider it necessary to have had a pre-sentence report for purposes of assessing whether you are a dangerous offender. Although the offences of which you have been convicted concern only 1 woman, it is clear from the evidence, including your prior convictions, that you pose a significant risk to women generally of serious harm occasioned by the commission of sexually motivated acts of threatened and actual violence. I find, in other words, that you are dangerous.
As the trial judge, Mr Justice had a duty to give due consideration to a life sentence for the convictions concerned. He showed that it isn't literally a life sentence, a whole life order, but that could change.
I am required first to consider whether I must impose a sentence of imprisonment for life, given the seriousness of each of these offences. Having regard to the seriousness of each of your offences individually and together, as well as everything else I know about you, including the facts of your prior convictions for similarly sexually motivated violent offending against women, I conclude that I must impose on you a sentence of imprisonment for life. It will in fact be 3 concurrent sentences of imprisonment for life. This is not a case of such extreme seriousness that it is necessary to impose a whole life order. In other words, an order under which there is no possibility of you being released. If I'd been sentencing you to a determinate sentence, taking account of the numerous aggravating and limited mitigating factors in this case, but avoiding double counting, after a trial I would have sentenced you to concurrent sentences of 24 years imprisonment for each offence. Because you would have served up to 2/3 of that sentence in custody, I fixed the minimum term you will serve at 2/3 of 24 years, that is, 16 years. Finally, I reduce that minimum term of 16 years by the number of days which you've spent on remand in custody, 280 days. This means that the minimum term which you will serve before the parole board may consider your possible release is one of 15 years and 85 days. It is important that you and everyone concerned with this case should understand what this means. The minimum term is not a fixed term after which you will automatically be released. You must serve every single day of that minimum term. And it must be served before the parole board can undertake their first review of the case. At that stage, they will review the risk that you then present and will consider whether you can properly be released from custody subject to license at that stage, and if so, on what terms. If and when you are released, you will be subject to license, and this will remain the case for the rest of your life. If for any reason your license is revoked, you will be recalled to prison to continue to serve your life sentence in custody, and it may well be that you will never be released again. It follows that unless and until the parole board consider that your release is appropriate, you will remain in custody, and as I've just said, possibly for the rest of your life.
Plumb is banned from ever making any sort of contact with his intended victim. If and when he's ever released, he will be on report to the police for life. There is, however, one concession for him.
In order to protect Ms. Willoughby from further harassment, you will be subject to a restraining order prohibiting you from contacting or attempting to contact her directly or indirectly, including via social media, email, telephone, post, or text message, and prohibiting you from entering an exclusion zone shown in a map attached to the restraining order. The restraining order also prohibits you from attending as an audience member or for any other purpose any television show or other public event that Ms. Willoughby is presenting or appearing in or at. This order will last indefinitely. I certify that you've been convicted of a sexual offence, so that you must for the rest of your life keep the police informed at all times of your personal particulars, the address at which you are living, and any alteration in the name you are using. You will be given full details of these requirements on a form at the end of this hearing. Given that I will be imposing a life sentence for each of your offences, it is not necessary for me to make a sexual harm prevention order against you, as the risk that you pose in that regard will be adequately managed through the management of your life sentences.
Plumb is barred from working with vulnerable adults forever.
The offences of which you have been convicted are ones that will make you subject to barring from working with vulnerable adults. You will be told of the restrictions under the Safeguarding Vulnerable Groups Act 2006 by the Disclosure and Barring Service.
As I understand it, this means that he's automatically banned from working with children forever too. If ever he's released, won't his criminal convictions automatically prevent him from working with either vulnerable adults or children, or in most other sectors anyway, even without any sort of official ban on top? That said, despite his 2 previous convictions, he was able to work in the security industry, so for the sake of public safety, especially for my fellow women, I honestly hope Plumb just stays in prison forever. But Would the police investigation into the allegations against him have been so strong? And would he have got a life sentence if his intended victim hadn't been a beautiful, famous white woman? If you've enjoyed this video, I recommend you to watch this one next. I'll meet you there.